Good afternoon. I was told by a lady at lunchtime that she thought my title was a bit boring, and I was trying to think of a better one. It's a bit more exciting, just a bit difficult. But I was reminded of something they used to say during the civil rights movement in America, where they would tell people who were going out in a campaign not to mau-mau the flag catchers. So I thought I should change my title to Deputy New South Wales Flag Catcher, which basically does clearly describe a lot of what our role is about. Okay, so I'm going to be talking about managing what we call unreasonable complainant conduct. And that sort of conduct is not a recent phenomenon. In a paper presented back in 1985, former Justice Michael Kirby, who was the president of the New South Wales Court of Appeal, and he was talking about ombudsmen, but it applies to complaint handlers everywhere. He was saying one of the universal problems of the ombudsman is the chronic complainer, people who feel passionately about their cause and uncompromising in their reaction to a negative conclusion on the part of the ombudsman. Such people can sometimes cause a great deal of disproportionate disruption to the work of an ombudsman and his staff. Now, over the last decade or so, the Australasian parliamentary ombudsman, most of the other complaints commissioners or industry ombudsmen have noticed a trend. And that trend is that there are more and more people who are demonstrating conduct that we find to be unreasonable, and the seriousness of that conduct is becoming greater. I used to be a complaint handler back in my 20s, and I can tell you that the types of conduct that we would experience back then is nothing like what happens today and what people believe to be acceptable today. Now, in discussions with complaint handlers from primarily Canada, America, England, we heard that they have experienced a similar trend, that there is an increase in the number of people and an increase in the seriousness. I used to think it was a purely Western phenomenon until we started doing some training in Asia, where we discovered that it really isn't the case. Our manual has now been translated into Mandarin, into Farsi for the Iranians. We've had people coming to the training from the Philippines, Thailand, Indonesia, Malaysia. And while the conduct is different depending on the cultural background, they're all experiencing significant problems in how to deal with behaviour they find particularly challenging. So we're seeing more and more people who are particularly angry over a significant period of time. They're aggressive, abusive, threaten harm, dishonest or intentionally mislead, deliberately withhold information, insist on outcomes that are clearly unreasonable or inappropriate. Now, our starting point is that people who have a complaint have a problem. They don't come to us if they're happy. Okay, so we are only dealing with people who will have various degrees of upset, who will be certainly angry. They might be exhibiting all sorts of behaviours that are, quite, if you like, robust. Now, that's just part of our job. That is part and parcel of the work of a complaint handler. What I'm talking about today are the problems that occur when conduct that is difficult, as in challenging, becomes unacceptable. I'm talking about conduct of a small percentage of complainants, and it's generally a very small percentage of complainants, that causes work health and safety problems for the staff of an organisation, that impacts on the limited resources of an organisation that are available for complaint handling, and that can significantly impact on the equitable distribution of resources between the people who are or the other people who are making complaints, or potential complainants. Now, what complicates the situation no end is that people whose conduct we perceive to be unreasonable are likely to view their own conduct as being entirely reasonable in the circumstances. Now, I remember hearing a quote from Mike Myers, the comedian. He was talking about something his mother said, which was that even villains are heroes in their own plays. Now, how reasonableness or fairness is assessed can vary significantly depending on the perspective of the person making the assessment. And while, for example, the subjective judgment of a complainant that their conduct might appear reasonable is based on their cause, the judgment, and I'd hope to think more objective judgment of a complaint handler, is based on the impact. So a complainant is sitting there going, because you did X, or because X happened to me, I'm entirely entitled to behave in a certain way. It's quite reasonable. Whereas the people experiencing that have a totally different perspective of it. So it isn't about saying that it's clearly and obviously wrong to everybody concerned. Okay, so the Australasian Ombudsman got together to work on a project to develop strategies to manage conduct that we find to be unreasonable. And we're talking about managing it. We're talking about dealing with the conduct in such a way that we don't ignore the fact that many people who do the things we find unacceptable actually have an issue. They've just adopted a suicidal approach to a call for help. So we worked on developing strategies to manage the conduct that we find problematic, and we found that it was easier to develop strategies if we categorised the conduct. So we identified 5 categories of unreasonable conduct. Each has its own approach to the response. And the first, of course, is unreasonable persistence. This is a very common one, where people persist with a complaint even though it's been dealt with to finality. They refuse to accept the complaint handler's decision. Excessive correspondence, the list goes on and on. And the principle behind the strategies to deal with that is about actually saying no and meaning it. Secondly, we have unreasonable demands, and that includes people who want outcomes that are unattainable, that they want the complaint handled in a particular way. Again, a long list of demands that are often made. And there it's about setting limits, setting clear limits, saying we will do X, we won't do Y, and we expect you to do A, B and C. Lack of cooperation, again, you would think that people who wanted help would cooperate, but that is certainly not always the case. And we have people who deliberately withhold information, act dishonestly, they provide disorganised information when they're capable of organising it, who refuse to define the issue of complaint when they're capable of doing so. And there again, it's about setting conditions. If you don't do X, we will not do Y. We can't help. And unreasonable arguments. There we're talking about people who see cause and effect links where there clearly aren't any, holding conspiracy theories unsupported by evidence, irrational interpretation of the facts, and focusing on excessively trivial matters. And that's about declining or discontinuing either all of it or the bits that we find to be unreasonable. And of course, the final is unreasonable behaviour. And there we're talking about anger, aggression, threats, threatening conduct. And there, basically, it's about risk management. It's about having the right procedures and policies in place. It's also about zero tolerance, so that your staff should not be expected to put up with that sort of behaviour, and you have a legal obligation under work health and safety laws to make sure they don't have to. So what are the causes? What leads people to behave in ways that we find to be unreasonable? And the first I'd talk about is attitudinal. I mean, you've got some people who are dissatisfied with life, the world, individuals, Got others who need to vent, desire to express their feelings, have their views heard, let off steam, have their day in court. For a number of them, getting a concrete outcome isn't as important as actually being heard and believing they've been heard. Second, we've got aspirational, and you'd have issues, for example, a rigid focus or fixation on an issue as a matter of principle. Very scary words for a complaint handler. When somebody says it's a matter of principle, my instruction to our staff is they have to stop them immediately and try and talk to them about where they're going. Now, some people run a crusade on a matter of principle and achieve magnificent results. You know, the Erin Brockoviches of this world. Most don't. Most move down, from my experience, they become obsessive, and it goes on and quite often will ruin their lives. So really they need to have somebody talking to them at the outset about just what are the chances of success, what evidence would they need to prove their case, what might happen to them if they proceed on. Vindication, retribution and revenge, very common objectives of people who go down the path of unreasonable conduct. Sometimes they want public recognition of the injustice they suffered, of the seriousness of the issues, of the battle they've waged in the public interest. Although generally speaking, when you look into it, it turns out that the issue is primarily a personal one to them, and certainly not as important as they believe it is to the public generally. The retribution angle, people want people dismissed, they want compensation. In my experience, it tends to start at $1 million, nothing less. And, you know, again, I instruct our staff, in most cases, they should say to people, whatever happens here, no one's getting dismissed and you're not getting $1 million. And people should be told that at the outset, not left till it's too late. Revenge is another one. People make complaints not to get an outcome, but purely because the complaint creates difficulties for the person they've made the complaint about. Then we've got emotional and psychological. One of the problems that we experience are people who their complaint turns into a campaign, and that campaign becomes an integral part of their identity. It is them. They fuse with their complaint. And they will continue with this because they have nothing else. I mean, that is their life. And some of them, if you get close to achieving the outcome they've been looking for, will move the goalposts. So they'll continue with their campaign whether or not the proposed outcome meets their original objectives. We have an infallibility, I'd put under that one, that some people are absolutely convinced they are right, and that any complaint handler reaching a different conclusion is either incompetent or corrupt. And this is quite a common scenario. If you don't agree with them, you're obviously covering up, therefore it's a conspiracy, therefore you're corrupt. And then a complaint will be put in about the corrupt complaint handler. And I say that from experience. Control comes under that heading. A lot of people want to have some control over what's happening with their complaint. We find that's one of the primary triggers for conduct we find to be unreasonable, is attempts to take control over that complaint. And it comes down to a mistaken belief on the part of the complainant that they own their complaint. And they don't. They might own the issue, they don't own the complaint. It's the complaint handler who owns the complaint. They're the ones who are going to be held accountable for how it's dealt with, whether it's properly assessed, whether it's properly handled, what the outcome is. And this should be explained to people at the outset. The complaint is owned by the complaint handler. The issue's theirs. They can do what they like with it. Expectations is another. Anger or frustration due to an unmet expectation. There's another one that's it's all about me. Unreasonable sense of entitlement. It's not my fault inability to accept responsibility. Then you've got certain disorders, for example, litigious paranoia, which leads to vexatious litigation, and querulous paranoia, which leads to querulent complaining, and I'll talk a bit more about that later. And of course you've got the irrational due to the effects of alcohol, drugs or mental incapacity. And I guess if I've got a favourite, it's recreational. That's people where it's a hobby. We experience it in the New South Wales Ombudsman, primarily in our local government jurisdiction, where retirees, generally male, it's what they do to keep themselves active in retirement. And they can wreak havoc in doing so. I suggest to people when I do training that it's people who don't have a shed. And it'd be cheaper to buy them one. But the reason I've gone into this list is to emphasise that not all the people who engage in conduct that we find to be unreasonable have personality disorders or psychiatric illnesses or intend to be a nuisance. They're not all mad or bad. Secondly, complaint handling staff are unlikely to have the professional qualifications to identify such personality types or psychiatric issues if they existed, and would be on very unsafe ground if they tried to and based a decision on that. Now, even if they did have that sort of background, they don't normally have the face-to-face contact sufficient to be able to make such a judgment. Now, I wanted to come back to querulence. Anybody here heard of querulence? Hands up. Anyone heard of it? No? Okay. Querulence, querulent complainants. What I'm talking about is the behaviour of some complainants that are viewed by complaint handlers almost universally as the most problematic. Querulence comes from the Latin, it's a plaintive murmuring or to complain. It was written about by people writing in psychological literature back well over 150 years ago, and then was largely forgotten about for a long time until work was done by some people in Victoria. Dr. Grant Lester, Professor Paul Mullen, and certain others. They wrote an article which was published in the British Journal of Psychiatry in 2004, which was entitled Unusually Persistent Complainants. And they had basically done research through the Victorian Ombudsman, Healthcare Complaints Commission, I think the Victorian Office of the Commonwealth Ombudsman, and they'd analysed a whole series of complaints, and they'd identified certain behaviours. People who pursued their complaints for longer, including after the case was closed, produced greater volumes of documentation, telephoned more frequently, engaged in behaviour that was more difficult and intimidating, wanted what a complaint handling system is actually not designed to deliver, which is vindication, retribution and revenge. And they associate those behaviours with querulousness, a psychiatric diagnosis. The behaviour appears to develop slowly over time, possibly over some years, so complaint handlers are likely to experience people at various stages of that development. And the types of behaviour we're looking at, which I find personally fascinating, and we're talking about behaviours here that often individual complainants might exhibit one, maybe two of these characteristics, but if somebody is a querulent, then they will exhibit numerous of these characteristics. So the first one, behaviours disproportionate to the motivating loss or injury, particularly once it becomes the prime focus of their life. An emotionally charged belief they are unjustly treated, a rejection of any responsibility, quest for total vindication, retribution and revenge, over-optimistic expectations of compensation or punishment, a strong belief their issues far greater importance than the facts indicate, logical and clear reasoning, but the underlying assumption that is the foundation of their view is incorrect or unfounded. Often it starts with emotional reasoning. They believe something to be true, therefore it is. Everything from there is based on actually rational reasoning. We had a particular person in New South Wales who the foundation for his issue, I personally believe, and everyone who's ever looked at it believes there was nothing in it. He firmly believed it was true, even though there was no evidence to prove it. He went on, in the end, he had, I think, 80-something decisions of the Administrative Decisions Tribunal, 16 decisions of the Supreme Court, and about 8 decisions of the Court of Appeal. Now, he actually won a number of the Court of Appeal decisions as a self-litigator. So he wasn't dumb. He was an academic. Never got anything he wanted. I mean, he was looking for documents, never got any of them, any one on points of law. But the point was, he reasoned logically, he reasoned clearly, everything was beautiful except for the foundation on which it was all based. And that's a problem not limited to people who might be querulent. Next issue, the underlying assumption at the core of their quest is held with an absolute conviction that is impervious to reason. They cannot be deflected from their course by logical argument about the flaws in or the merits of their case or the appropriateness of their conduct. And it comes down to the old principle that you can't change a person's view through logic if they didn't arrive at it through logic. And in my experience, that is very true. They also have a loss of focus over time. A number of grievances grow and escalate and multiply, and the number of parties increases. Another sign is that written communications, idiosyncratic look, uppercase, lowercase, bold, underlining, highlighting, writing in the margins. Anybody seen anything like that? Okay, well, can I say it's not determinative? I mean, my speech notes look like that. But it is a sign that possibly somebody has gone down this path. And this was one of the things discovered by Professor Mullen and Dr. Lester when they were looking at the various correspondence from the people the subject of their study. As I mentioned before, well, I'd mentioned about hobbyists, but basically it applies to all of them. 70 to 80% apparently are male. It first manifests when they're in their 30s to 50s, although it can be a period of years in between onset and first manifestation. Part of the reason why I find this topic so important is that a number of the people who I would classify as querulent end up committing suicide. Dr. Lester, while we don't have a census of how many there are, Dr. Lester is of the view that 20, maybe 25% commit suicide. But the other interesting thing is where Dr. Lester and Professor Mullen got interested in this topic. Now, they work in the Thomas Embling Forensic Hospital in Melbourne. And they got interested in the topic while dealing with their clients, generally murderers who were locked up because of mental, well, they were, I think, acquitted on the basis of mental health problems. That's where they identified a number of those people as exhibiting the behaviours associated with querulence. I'm not saying that every person who does the things I've described is going to run in and shoot your staff, but there have been occasions where people exhibiting these behaviours have been violent to others. There are cases where they're violent to themselves. Most of the people who go down this path, it's a downward spiral, and I have very seldom ever seen anybody who ever came back up. I used to say nobody, and then we got a letter last week from a woman who thanked us for, if you like, it was almost an intervention, which she said had caused her to reconsider what she was doing. And she was somebody who exhibited a number of these characteristics. But that is very rare. I've only ever seen people who get off at a certain level And that's generally, when we've explored why, it's because they've set up a website and they're telling the world. And they're happy for a period. So, maybe we should be giving more difficult complainants manuals about establishing websites. I've had people say to me, well, you don't want that sort of stuff on the web. And you say, well, look, if you go and look at these sites, what they've got on there is just so over the top. There is no credibility to anybody else but a like-minded person. Now, I want to talk a bit about what happens when a conflict escalates. And has anyone here heard of Dr. Friedrich Glassel? Anyone heard of Dr. Glassel? Okay. He's a Swiss gentleman who developed a 9-stage model of conflict escalation. Actually goes down, but it's a 9-stage model. He did it in the 1990s. Not much came into English-speaking world until probably the 2000s, when his original works, which were in German, were translated. And I find if I put together the Glassel model and the work of Mullins and Lester in terms of complaint escalation, it really does give insights into what we can expect as a complaint escalates from just a mere, I don't like what you did. And I think an understanding of this may assist complaint handlers to address and appropriately respond to these issues. And if we look at the 9 levels, and he divides them into 3 stages. There's win-win, win-lose, lose-lose. So this first one is hardening. And that's where the party or parties, now he talks about both parties, but it works just as well where one party has decided there's a conflict and the other one doesn't even know. The focus of that person is still on finding a solution at this stage, but in the context of a fixed and mutually inconsistent views. Glassel describes personal differences where the relationship between the parties then breaks down, and there will also be what Glassel talks about as conflict about the conflict, where the reasons and background to the conflict are interpreted differently. And this moves on to debates and polemics, where there's the use of emotional arguments, quasi-rational arguments used to advance the cause. It's decreasing trust, increasing resistance to rational argument, then to actions, not words. At this level, the focus of the complainant is likely to be on blocking the other party from achieving its goals. At this stage, the complainant may well disagree with the way the complaint is being or will be dealt with. Very common experience for us. And Glassel refers to that as conflict about the conflict resolution. Then we move into the win-lose stages, negative perceptions about judgment. So at this stage, the focus of the complainant will be on winning and no longer on the substantive issues in dispute. Over time, negative images of the subject of complaint or the particular staff of the complaint handler may dominate whenever there's an interaction. At this level, somebody's probably going to try and enlist the assistance or the support of others, and where we're seeing this sort of behaviour at the moment is through the use of social media. And again, this is about negative perceptions about judgment. So they haven't moved to the next phase, which I find fascinating, and that's where it's negative perceptions about morality. What Glassel says, and what I've seen myself, is that at this level, people experience a revelation. And the revelation is that the person isn't merely wrong, they're evil. They make a moral judgment about what that person is like. And they decide they're unethical, immoral, malicious, dangerous, corrupt, criminal, or just plain evil. Any one or more of those particular things. I actually find this works very well when I'm looking at friends going through divorce. There is a stage in those proceedings where one or both decide the other is actually evil. And at that point, everything beforehand is reinterpreted in the light of that revelation. They're not just wrong. It wasn't just their judgment was wrong. They're evil. I don't mean in a religious sense, I mean that they're somebody who's morally corrupt, unethical, etc. So then we move on to level 6, strategies of threat. And so they'll start making threats of sanctions, threats to escalate the dispute, for example, to the media, CEO, relevant professional bodies. And there might even be veiled threats of harm to persons or damage to property. We go to the lose-lose phase. So we've got limited destructive blows, so they actually apply the sanctions. At this stage, malice is the driving force. And the calculation of consequences becomes increasingly skewed. What the complainant perceives as losses experienced by the subject of their anger, they count that as a gain, even though they've achieved nothing in terms of the substantive issue underlying their complaint. Fragmentation of the enemy, that's where there's a targeting of supporters and allies, and that's where you will get complaints, and then complaints about the complaint handler, etc. And the final one is together into the abyss. Somebody's prepared to destroy themselves as long as they can bring down the other party. And that's where in the querulent context you might have somebody who will commit violence. Okay, so one of the reasons why I find the Glassell writings fascinating, apart from the fact that it just does resonate with all of the circumstances that I've been witness to in 30 years where things have gone very bad, is that his writings emphasise the importance of communication as pretty much the only way to prevent or minimise the escalation of a conflict. And we're talking about direct communication, preferably not through lawyers. And it highlights the fact that unfortunately, human nature being what it is, the people we least want to talk to are probably the people we most need to talk to. And the failure to communicate and the failure to have ongoing communication leads to these sorts of changes in the interaction. And so what are the impacts? What are the detrimental impacts of the sorts of things we're talking about here? Certainly there's the obvious one. There's the stress caused to staff. Might actually be dangers to their health and safety as well. And it's quite common that some people are going to attack the people they see responsible, and often in very intemperate terms. It's only at the very extreme end that we might actually see violence. Although I did see a newspaper report from the Northern Territory Ombudsman just a few days ago where they've just had to evacuate their office because of bomb threats. For some reason we don't get them anymore. We used to get them quite regularly, but they've moved on. Resource implications, massive resource implications. The number of complaints made by some people, the way they pursue their complaints can have a disproportionate impact. From detailed discussions and surveys of complaint handlers around Australia in particular, but discussions with complaint handlers from around the world, once we've talked them down a bit, because they tend to get a little bit worked up, what we end up with is that it's generally agreed between 3 to 5% of complainants might go down the path of being what we would call unreasonable. Some organisations have none. Some say that 70%. Interestingly, the Northern Territory and Alaska both came up with that figure. 70% of their complainants are unreasonable. Might have something to do with the type of people who live in both places. Because one's a cold version of the other, basically. All right, so we decided we're fairly safe on the 3 to 5% figure. And then when we looked at how much resources are involved in dealing with that 3 to 5%, the general consensus is 25 to 30%. Now, there are the exceptions. There are numerous cases I'm aware of where 1, maybe 2 complainants have taken up 70 to 80% of the complaint handling resources, if not more resources. of an organisation. I've seen one complainant, particularly skillful at doing this, who almost brought an organisation to its knees. And of course this raises as well the equity issues about the amount of resources available for the other users of that service. And finally, there's the personal impact on the complainant. As I said, once people start going down this path, they destroy themselves. It is a downward spiral. Very few people come up. And Mullins and Lester talk about the gradual but ultimately devastating social decline, in the course of which vexatious litigants and unusually persistent complainants have laid waste to the financial and social fabric of their lives. And what they're talking about there is the fact that the people who go down this path generally end up, if they had a partner, that's gone, their family won't talk to them, they're unemployed, they're bankrupt. And if they do something seriously silly, they're either in hospital or in prison. So we're talking about people who destroy themselves. And not just themselves, it's a ripple effect. It affects their family, it affects their friends. Now, we can't change people. In the complaint handling context, we cannot change people. We have to deal with them as we find them. But we can change how we respond to them. So, there are various strategies, and we've developed a manual that you can download from the New South Wales Ombudsman website, and a model policy which talks about the various strategies that are available that are reasonable and fair to deal with people exhibiting these sorts of behaviours. And it's about managing a person's interactions with our organisation, our staff, their access to our services, expectations about the process we're going to follow, perceptions about the fairness of the process, perceptions about the fairness of how they were treated. So just to talk about a couple of those sort of strategies. And one is that if you have reason to believe that somebody is fusing with their complaint campaign, if it's becoming an integral part of their identity, the best thing you can do for them is to decline that complaint. Refer them to some appeal body, but you really should decline that complaint. Some years ago, Professor Mullen came and talked to a number of the complaint handling organisations in New South Wales, and he was asked, what can you do? Can people who are exhibiting these behaviours be cured? And he said, no, there is no cure. There is no medication you can give them. He said the best thing you can do if you identify somebody who's going down that path is to cut them off early, not later, because otherwise they're just aiding and abetting in the destruction of their life. Next one is by clearly explaining the evidentiary requirements at the start. Sounds simple, hardly ever done. We should be saying to people, the sheer fact that you believe it to be true is not enough. We will need evidence that is objective, that is separate to you. Because a lot of people believe that they are right, therefore. If you don't believe them, one, you're threatening their whole identity. But secondly, it means that you're in on it. We should be explaining to people at the outset what will need to be proved, what they'll need to prove or what we will need to find, and the chances of doing that. Thirdly, it's about managing expectations of the complainant. The primary way to prevent complainants from going down a path we don't want them to take is to manage their expectations from the outset. To tell them when they come in the door, effectively, what you can do, what you can't do, what you will do, what you won't do, when you're going to do it. And the starting point is to ask them what it is they want. How do they think it's going to go? What do they expect to be the outcome? Then you have the hard conversation at that point. And if you aren't certain that you can achieve the outcome they're looking for, you should be telling them that at the start. Secondly, we need to manage the expectations of our complaint handlers. Far too often, they have a very unrealistic expectation of the whole process. Too many of them believe they can actually bring a complainant round to their way of thinking. And in many cases, that is not going to happen. But they'll keep trying. One more try. I'll give them one more try. If I just try and explain it better, I'll get through to them. Quite often, not going to happen. Second thing is many complaint handlers believe they're not successful unless they achieve a satisfactory outcome for the complainant. And again, wrong measure. Okay, have a satisfactory outcome, but it's got to be a satisfactory outcome for all concerned, for the organisation, for the complainant, in the public interest. Some of our best outcomes have actually been to the detriment of the complainant, but they achieved magnificent outcomes in the public interest. We don't count that as a failure. If you can help a complainant, that's fantastic. But if they do not deserve warrant, if it's inappropriate, if it can't be proved, etc., then the fact that the complainant is not satisfied is not the sign that something's gone wrong with your complaint handling process. It might be a failure of how you dealt with the complainant. And certainly there is a large amount of research across the world into what's called justice theory. And what justice theory says is that there are 4 dimensions to a decision-making process or to any process. One is the outcome. The second is the procedures used, whether they're perceived to be fair. The third is how the person was treated, whether they're perceived to be treated fairly. And the fourth is that they were perceived to be given adequate information at the right time. And what the research shows, if people believe the process was fair, they were treated with respect, and they were given adequate information at the right time, they will generally accept an outcome that is unfavourable. This is research across the world. Thousands of research projects have been done into this, and they've found largely the same results. People are far more likely to accept an outcome that they didn't like if they believe those things are fair and reasonable. In the medical context, it fits in with the whole thing about open disclosure, about giving adequate information at the right time, treating somebody with respect, and having a process in place that they perceive as being fair and reasonable. Okay. And of course, admitting errors and apologising. And in that context, we're talking about communication. People have already talked to your conference enough about apologies. I won't go into that, although that's one of my favourite topics. The key issue in the complaint handling context is getting in early, apologising when, as soon as you realise that you've done something wrong, showing sympathy before that. And bear in mind, of course, if you are from Queensland, New South Wales or the ACT, there are limited legal consequences if you actually admit fault in the course of giving an apology. Those 3 jurisdictions have passed statutory protections against civil liability. So if you are giving an apology and in the course of that apology you admit fault, it cannot be used against you in civil proceedings. Okay, I talk about apologies regularly at various legal conventions. I think out of all of them, including judges, I think I've only ever had one lawyer who was aware it was there. I mean, it only has been there for 12 years. Queensland have got a bit more excuse. I think you only got it 2 years ago. But the protection's there and you should use it. If you've got lawyers telling you shouldn't apologise, point that out. Okay. Now, just very quickly before I finish up, I want to talk about social media. This is the growth area for unreasonable complainant conduct. That's generally accepted view across complaint handlers across Australia. As part of the project to update our manual on unreasonable complainant conduct, we conducted focus groups across Australia of public officials from all levels of government, all different types of agencies, and I think we had something like 95 agencies, 25 focus groups. One of the 2 common issues across all of those groups was the misuse of social media and the problems that this caused, and the just bewilderment about how they should respond, who should respond, when they should respond. So we've built into our manual some guidance about actually responding to attacks in social media. Just incidentally, the other issue that was common to them all was the interference of ministerial advisors. And that was even for councils who don't have a minister. Okay, so there are a growing number of people who are engaging in things like cyberbullying. They're emboldened by not having to witness the victim's immediate response. They are doing things anonymously that they probably wouldn't do face to face. They're using this technology to do some things which are really quite outrageous. And what we advocate in our manual is that agencies should take, or any organisation really, should take a proactive approach, whether or not they have a social media presence. They need to develop and adopt policies for responding to inappropriate and unreasonable online content. They need to use online tools and alerts to monitor discussions about their organisation. They need to develop and adopt a social media policy to guide their staff in their use of social media, both at work and at home. Implement a set of rules for complainants on what is seen as being acceptable and unacceptable uses of social media. And of course, treat unreasonable conduct online the same way as unreasonable conduct generally. So, step one, of course, if there is unreasonable content, first I guess you've got to monitor to find out if there is. So you need to have people within your organisation who actually have the responsibility of monitoring. They might not do the monitoring themselves, they might use online tools, but somebody has to be responsible for managing the organisation's online content and responding to problematic online behaviour. At least one person needs to have that in their job description. That is my job. Some organisations, of course, have numerous. I can't remember how many the New South Wales Police have. They do an extremely good job at monitoring and responding to online comment. And of course, the online listening tools are easy, they're cheap, and they should be used by all organisations. Of course, then you need to evaluate the comments. And you need to decide, for example, whether... where are we? Is the content unreasonable? What's the purpose or the apparent purpose or objective of the content? Is the online content highly visible, easily accessible? What impact will the content have on your organisation? What are the circumstances surrounding the online posting? What are the terms of use of the hosting service? And those terms of use are becoming a lot better in terms of being able to get a response and have things removed. So in terms of responding, first question, who should respond? And, for example, you've got a moral or, if not legal, responsibility to assist and protect or counsel staff on any issue arising out of performance of their duties where that results in inappropriate online content. But should it be the staff who respond or should it be the organisation? Possible responses, or public responses, sorry. And there's, of course, very strong rules that those should be unemotional, restrained, never include personal attacks, never enter into he said, she said debates. And the rule seems to be brief, fair, informative and friendly. So BF, IF. And that includes, if appropriate, acknowledging that people have a right to different views, trying to educate the commenter on where the content is clearly incorrect or misleading. If you've done something wrong, to apologise and advise what you're going to be doing to correct it. Private responses, of course, are relevant where the online content is essentially private. And that could be by email, letter, telephone, face-to-face. Both public and private might be relevant where, where the content appears credible, it's spread across the internet or through social media, targets specified members of your organisation and is unlawful, then you need a far more comprehensive response. You might still go for a private response to talk to the individual, but you also need to address the public issues. And of course, you've then got the legal response. If something is a breach of The law, for example, that's quite an easy one. You refer to the police. If the online content is the breach of the terms of service or rules or community guidelines of the service hosting the content, then you need to contact them. There is, of course, technically, theoretically, the possibility of taking defamation proceedings, but by and large, in terms of defamation, Dante's comment above the doors of hell should really be above the courtroom door. You know, abandon hope, all you who enter here. Follow up and follow through once the online content has been responded to, either directly or indirectly. You should continue to monitor the internet, maintain an awareness, and of course supporting affected staff. You're responsible for providing for the health and safety of your staff, and it might be that staff need counselling, and maybe you need to provide your staff with a message of support. And if it has been a public posting, then maybe it needs to be a public message of support. Just a quick note of caution. Social media is not going to go away. You need to give up ambitions to try and control the conversation. Ultimately, you can only hope to influence it. So, to conclude, numerous experienced complaint handlers from across the world have identified that unreasonable conduct is a growing phenomenon that's causing more and more problems for us. More and more complainants doing things that really are unacceptable. We've developed guidance. You'll find copies of that on the New South Wales Ombudsman website. There'll be a manual and a model policy, and also fact sheets about responding to inappropriate online content. There's also a lot of other publications there you might find useful. Particularly, we have a manual that we've prepared, a guideline on apologies, a practical guide. All of these can be downloaded free of charge. The apologies one is particularly popular. It's designed around the fact that while the concept of an apology is very simple, the things that can go wrong are just legion, and that if you don't do it properly, you can't do it again. So it contains a lot of guidance about what should be and what shouldn't be and how it should be done. Okay, thank you.